The justices are robing up. I've gotten my steps in this morning, going up and down the staircase. We're going to hear two cases today. The first case is 60 minutes, and we will take a break after that case, but just very quickly for the judges to refresh themselves and come right back to the bench, and then we'll hear the second case. I noticed people have Lester, you're okay, but other than Mr. Tate, if everyone else who has water or coffee cups or anything, if you just please put them under your chair during the session, we'd appreciate it. Also, there, except for media, there's no recording or taking of photographs during the session. And we're really glad you're here. Thank you.
The Honorable Supreme Court of Georgia is now in session. Chief Justice Michael P. Boggs presiding. You may be seated.
Mr. Chief Justice.
Good morning, Mr. Tate.
How are you?
Well, sir. Welcome.
On behalf of the people of Bartow County and my brothers and sisters at the bar, I'd like to welcome you, Mr. Chief, and all the associate justices to Bartow County this morning. Visitors are also welcome. We've got a lot of distinguished folks here. I'm not going to try to go through all of those. As some of you may know, this court and our community share a pretty historic relationship. 179 years ago, this court, in fact, this month on March 31st, this court issued its opinion in Peoples versus Trulock, which was issued in Cassville, Georgia. This was then Cass County. And I'm proud to say that Warren Aiken, of my firm and the great-grandfather of Morgan Aiken, my longtime law partner, was the one to argue that case. He lost, but we don't hold long grudges. We also are extremely proud of our son of Cartersville and Bartow County, Robert Benham. Robert Benham, as most of you know, was the first African-American judge to serve on any appellate court, the first African-American judge to serve on this court as an associate justice and as a chief justice. As the philosopher Thomas Carlyle once said, "Show me the man you honor, and I will know what kind of man you are." As a community, we honor Robert Benham, and I certainly hope, Justice Benham, that it shows what kind of community we are, because to be able to honor you and all you've done through the years is just tremendous, both for our community and for me personally. I also note, Mr. Chief, that we are making history today in that I think this is your last time to preside in this court, and you will be joining me on this side of the bench at some point, and I look forward to having a case with you or against you and working with you continually over the years. You have been an extremely dedicated servant and a dear friend of mine as well, and so I wish you well. This is our history that I've talked about, but today we as a state and as a country are amidst a lot of division and a lot of strife concerning the prerogatives of government and the rights of individuals. And it's during these times that we turn to the courts to adjudicate those things. We turn to the lawyers to advocate for our position and to the judges to decide that. We place our trust in these institutions. And by placing our trust in these institutions, we show what we are as a democracy. I appreciate you all coming here today to let our community observe that process. And especially with young people, we have a couple of mock trial teams here from various high schools to enable them to see what this process is like and how we as a democracy function. But as most of you know, Oliver Wendell Holmes famously said that the life of the law has not been logic but experience. And I just want to say in closing today that this court, my law firm, our institutions have 179 years worth of experience. That's a pretty good experience to draw upon. And so, again, I want to say I think we have the tools to move forward with the rule of law to resolve these disputes. And I just want to thank you on behalf of the members of the bar and our community for giving us the opportunity to host you here today. Thank you very much.
Well, thank you, Lester, for the warm welcome and the kind comments, particularly your comments about Justice Benham. We're honored to be with you all today. Thank you also to Mayor Matt Santini, who's here with us this morning. I've not had an opportunity to meet yet. We're especially grateful for the opportunity to be in Cartersville because, of course, as has been mentioned, it is the hometown of our former esteemed colleague, Chief Justice Robert Benham, who is here with his lovely wife, Nell. Justice Benham, Nell, thank you. Thank you for your kindness, your generosity, your service to our state, and that's service by both of you. And we're so grateful, Nell, for you lending Bob to the court and to this state. Also in attendance today, we have members of the Cartersville High School mock trial team, along with their mentor coaches, Superior Court Judge Samir Patel and Ms. Heather Candela. I understand that despite being a relatively new team of first-timers, this group has performed well at the district level, both in Dalton and went on to compete at the state competition. And I'm happy to know that some of them have expressed an interest in pursuing the law as a career in their future option, as a future option. We also look forward to hearing about their future successes. I understand some of those students will be around as we finish up our arguments today to ask some questions of the court. So we look forward to hearing from them as well. We also have some fine lawyers here practicing before the court today. So for these young students, I hope you'll pay attention to what I know will be fine arguments by these lawyers, and you're going to be anxious to learn from and watch these lawyers present. Also, Chris Crowder is here today with family members. Where are you, Chris? Can't see you. Okay, wonderful. Well, it's nice to see you, Chris. Thank you. Thank you for your service to the court, to the presiding justice, but also to the court. We thank you for being here. Lastly, I'd like to take a moment of personal privilege to introduce you all to my colleagues. This is my last opportunity to do this, but I serve with, I think, the finest justices on any court in the country. And you should be proud of their service to your state, and I want you to know who they are. So we'll begin, as we do with everything, in seniority order, and I'm going to start with Presiding Justice Nels Peterson to my right, former Executive Counsel to Governor Sonny Perdue, the state's first Solicitor General at the Attorney General's office, served with me at the Court of Appeals, currently resides in Cobb County, and when I leave, will be the incoming Chief Justice of the Supreme Court of Georgia. To my left and next senior is what will be Presiding Justice Sarah Warren. Prior to becoming a justice, she was also a Solicitor General and a special counsel handling the water litigation, what you may commonly refer to as the water wars, where she did quite well. She's a resident of Fulton County, and I'm honored to serve with her and know that she will do a great job as presiding justice. Next is Justice Charlie Bethel, to my right, your left. Former state senator from up in this part of the world, from Dalton, served also on the Court of Appeals and is from Whitfield County. Next, Justice Ellington, to my left, served in multiple levels of state courts, having served as a presiding judge on every court in Georgia, to my understanding, at some point or another. He and I served on the Court of Appeals. He served as a state court judge and served by designation on multiple courts, including the superior courts of the 5 judicial circuits throughout South Georgia, and was a municipal court judge in his hometown of Soperton. He currently lives with his wife on their family farm in Truitland County. Next is Justice Carla Wong McMillan. To my right, your left, first Asian Pacific American appointed to our court and any court, as I understand. Formerly served on the Georgia Court of Appeals and was a state court judge in Fayette County. She and her family currently reside in Fayette County. Next, Justice Sean Ellen LaGrua. Justice LaGrua previously, like me, served as a Superior Court judge. She served in the Atlanta Judicial Circuit, formerly was Inspector General for the Georgia Secretary of State's office and Solicitor General in DeKalb County. She currently resides in Fulton County. Next, Justice Verda Colvin. Justice Colvin is a former Court of Appeals judge, a former Superior Court judge in Macon in the Bibb County, Macon Judicial Circuit, former Assistant U.S. Attorney in the Middle District of Georgia, and before that was an Assistant Solicitor in Athens, Clarke County. She and her husband currently reside in Macon, Bibb County. And last but certainly not least, Justice Andrew Pinson. Justice Pinson, to my left, previously served as a Court of Appeals judge, was also a former Solicitor General like Justices Peterson and Warren, and lives in DeKalb County. And then lastly, I'll simply introduce myself and say I'm Mike Boggs, and I have had the pleasure of serving as Chief Justice now for about 3 years. I've been on this court for about 8 years. Prior to this, I served on the Georgia Court of Appeals. I was a Superior Court judge in the Waycross Judicial Circuit. Prior to that, I served in the legislature. It's been my distinct honor, my highest honor, to serve on all of these courts and to be a servant to the public, which I view as an obligation of all lawyers and all judges. And so I've been honored to serve and honored that this is my last day on the bench will be served in Cartersville. So with that, I'm honored to be with you. Madam Clerk, do we have any requests for the admission of new members to the bar of the Supreme Court of Georgia?
Yes, Your Honor, the following named applicants have properly certified applications, and I respectfully move for their admission to the bar of the Supreme Court of Georgia.
When your name is called, will you please come up the stairs to the stage? Is that the way we're doing this?
Right in front.
Okay. This way? And stand in front of me. I don't bite, so get close, and I'm going to swear you in as your name is called. Please come in.
Zachary Beck, Zachary Guder, Aaron Harper, Allison Kirch, Megan Pasqua, and Corey Rosenberger. It's
a wonderful opportunity to admit new lawyers to practice before the Supreme Court of Georgia. I'm honored to have you all here today. Yeah, that looks good, just like that. If you all please will raise your right hand and listen to this oath. You do solemnly swear or affirm that you will conduct yourself as an attorney or counselor, truly and honestly, justly and uprightly, and according to law, and that you will support the Constitution of the State of Georgia and the Constitution of the United States. So help you God. If you agree with that oath, please say I do. I do. And you can put your hands down. Thank you and welcome. We look forward to having you before this court in the future. It is a tradition at our court that upon admitting new lawyers to practice before the state's highest court, one of our colleagues will give you some words of welcome and some words of encouragement. And today that duty falls to my colleague, Justice Charlie Bethel. If you will give your attention to Justice Bethel, please.
Thank you very much, Chief. And I'm thankful especially that you didn't encourage wisdom, is what I'm just encouragement. And
that's implied.
I'm not sure. I can do the welcome, and I will do that, and then we'll see where we go from there. And Ms. Pasqua, obviously, good to see a Dalton face here in Cartersville. So congratulations and welcome. As the Chief said, this is a long-standing tradition of the court. My theme in my remarks for you today is really inspired, it's borrowed from a great Georgia voice, but inspired by two friends of mine who are indeed themselves great Georgians. Reverend King is quoted as having said, "Everybody can be great because anybody can serve." And of course, most of us have heard that portion of the quote, but I think it's important to remember the rest. You only need a heart full of grace, a soul generated by love. Those are modifiers of the sort of service that Dr. King extolled for us. He knows I'm going to talk about Justice Benham, but because it's his last day on the bench, I'm also going to talk briefly about Chief Justice Boggs until he turns off my microphone, This month ends a continuous 25 years of service to the state of Georgia as a legislator, a Superior Court judge, a Court of Appeals judge, a Supreme Court justice. Those are the roles Mike Boggs has filled over the last 25 years. But he's done so in a manner that is greater than just a title, greater than just a list that you would find on a Wikipedia page. And I want to talk about the sorts of things that distinguish the service of Mike Boggs and encouraging you to think about the way you serve your clients, your communities, and beyond. It is not particularly easy to campaign on things like criminal justice reform, on reviewing artificial intelligence role in the courts and in the judiciary, and behavioral and mental health issues. But Mike Boggs didn't ask whether they were easy. He said, do they need doing? And because the answer was yes, he focused countless hours outside of casework, outside of the normal expectations of judges and jurists, because they needed doing. They needed doing for Georgia, and we benefit from that. So too with Robert Benham. Most of you can probably scarcely appreciate the pressure of me sitting in front of Robert Benham and talking about him. Robert Benham is an icon. He is a gift to the people of Georgia. A gift from our Creator, and a gift that he gave freely of himself. There were many options available to a young Robert Benham, born into a nation and a state full of great promises that were not fulfilled for him. He chose to be about the business of making us live up to those promises. He chose to serve. He chose to meet challenge with graciousness, with generosity, with courtesy, never to be mistaken for a lack of firmness or resoluteness, as any of us who have worked with or around Bob Benham can attest. But at every turn, he took the opportunity to look in the face of our failure and to love us nevertheless. I have heard stories of clients who had formally declined service to Justice Benham during his childhood right here in Bartow County. I could take all of my time listing the firsts of Robert Benham. First black law student at the University of Georgia School of Law. This is not some esoteric history lesson. This is the first black Georgian elected statewide since Reconstruction. The first black member of this court and our first Chief Justice. We are not removed from the failures of our past. This is part of a lifetime that we get to experience and appreciate and value. And no better person could embody those characteristics, in my view, than Robert Benham. And as the Chief said, he sits alongside Miss Nell, who walked all those steps with him. No doubt, those of us who have shared lives in matrimony, no doubt appreciating probably far more than he on occasion, how much he sacrificed, how much he walked past on the journey to a better Georgia. So Bartow County can be rightfully proud of its son, Bob Benham. And it is a privilege, as a fellow Northwest Georgian, who delightfully enjoyed the commute, by the way, from Dalton to Cartersville over Atlanta today. It is a privilege to be in your hometown and to hold this session of the court, because while we would probably not be here today because of you, Georgia would not be where she is today without you. And we are appreciative of your legacy. And so to our newly admitted members, you have an opportunity to dedicate your life to service, to dedicate your practice to service. And it won't always be easy, And there will be plenty of times when opposing counsel, perhaps a judge or two along the way, or others will show you that the system is imperfect. Because it is populated by human beings, it can't be any other way. But you can choose graciousness, kindness, love, compassion, and service as your tool of choice to make it better tomorrow than it is today. And in doing so, you will have rendered a service akin to that of Robert Benham. So welcome to the practice of our court. We look forward to hearing from you when the time comes. And I appreciate you blocking me just ever so slightly from all of these eyes as I speak. Congratulations and welcome.
Thank you, Justice Bethel. Y'all hang on one second. For the personal comments, thank you. It is indeed easy for you to find someone to emulate here today. Justice Bethel has lifted up, as he should, the great service of Robert Benham. Maybe you should think about, in your practice, emulating that life, a life where he embraced the duty that lies nearest. He embraced using the tools around him to serve others through service. And I want you to know that being here today is no coincidence, that we are honored that you're here being admitted on a day when we're honoring also Justice Bob Benham. So thank you all for being here. Now, if you'll follow the deputy clerk, you'll go sign the roll book of every lawyer that's ever been admitted since 1845 to practice before this court. And for a nominal fee, you will receive a certificate that we are that we say is worthy of framing. So with that, thank you all for being here. We look forward to having you back in front of the court at some point in the future. Thank you. This way. Also, these lights are a little different than the lights we have at the court. You'll excuse me if I can't see everyone and recognize others, but I did want to recognize another special guest here today. We have with us Judge Jeff Watkins from the Georgia Court of Appeals is with us today. Judge Watkins, thank you for being with us. With that, some further instructions. During today's session, we will hear arguments in 3 cases. The first 2 are related, and we'll have a total of 60 minutes for argument in that case, as provided by order entered by this court. We will take a break after that case. Each party in the final case on the docket will have 20 minutes for argument. If the opening statement does not last for the full 20 minutes, the remaining time may be used for rebuttal. Courtroom clocks are located, I think, where you can see them. When the yellow light appears, we remind you that you have 5 minutes to complete your argument. When the bell sounds, we'd respectfully ask you to conclude your speaking at that time. With that, Madam Clerk, will you please call the first related cases?
Yes, Your Honor. S25A0362, Republican National Committee et al. Versus Eternal Vigilant Action, Inc. et al. S25A0490, State of Georgia versus Eternal Vigilance Action, Inc. et al. Brian Tyson and Gilbert Dickey for appellants, Christopher O'Nulowitz and Teresa Lee for appellees.
Good morning, counsel, and welcome. You may begin when ready, Mr. Tyson.
Morning. Thank you. Mr. Chief Justice, it is a privilege to get to argue before you in your final argument as Chief Justice. We appreciate your decades of service to our state. May it please the court. My name is Brian Tyson on behalf of the state of Georgia. In the run-up to the 2024 general election, the State Election Board passed a series of rules regarding the election process. And as much debate as there was about those rules and as much debate as there is in the briefing about the merits of those rules, this court cannot reach the merits question today because no plaintiff here has standing to bring the action that is before this court. This court has been clear that in order to bring an action, a plaintiff must have a private right or a public right injury under the judicial power paragraph of the Georgia Constitution. And the plaintiffs that are before you today do not have a violation of their own legal rights. Now, this court has referred to voting as both a public right and a private right, depending on the case. And that makes sense because there are certain aspects of the right to vote that are very personal. And Wasserman, this court discussed that one of those, an individual where the case from Lord Holt and Ashby case, where the constable prevented somebody from voting. There was a direct personal denial of the right to vote. That was a private right of that individual. But there are other aspects of the election process that are implemented by the community as the community. The administration of elections, the counting of votes, the process by which we certify election results. Those are public rights held by the public, not private rights held by individual voters. And as a result, as this court looks at the issues in this case, it only has before it public rights, not private rights. And we can see that in each element of the plaintiffs that are before the court. So beginning with the individual voter plaintiffs, Mr. Turner and Mr. Hall both claim they have a denial of their right to vote. But the evidence before the court shows it's actually something different than that. What they're claiming is they're not sure if an election official might follow the regulations of the SEB versus the statute. And if that happens, then they might have an issue with counting or with reporting or with something related to their vote. They're not alleging that a poll worker is not going to allow them to vote. They're not alleging that there's a prevention of their personal right to vote. They're concerned about the public right of the administration of elections related to these rules.
Counsel, are there any cases that establish from our court this public right notion?
The only one, Your Honor, I think is Sons of Confederate Veterans. There's a reference to the 3 cases related to voters bringing actions about the administration of elections. What's unique about those is they're all mandamus cases. And so in looking at those, I think the court can say either the voting administration is a public right or it's enforceable through mandamus. It's not a public right. But I think in either case, it shows that the plaintiffs don't have standing here because they didn't bring a mandamus action. They brought a declaratory judgment action with an injunction.
Mr. Tyson, don't some of the rules at least potentially affect a voter's ability either to cast a vote or to have their vote counted? And wouldn't that be a private right that would be impacted by that?
So, Your Honor, I think the only one that could get there is the absentee ballot delivery rule, because that could affect a voter. The other rules, just to kind of walk through them, relate to the actions of boards of election. They relate to surveillance when voters are not present. They relate to activities when poll watchers aren't present, reporting of election results, or numbers of ballots. But I think the only one that could get close enough is that absentee delivery rule, because it does affect potentially affect a voter's ballot. The problem for the plaintiffs here is there's nothing in the record that indicates they plan to hand their ballot to a family member for delivery and that there may be an issue there. So the evidence doesn't support that private right claim here.
But the fact that they could possibly give it to a family member, doesn't that affect their right?
I think it could potentially affect their right, Your Honor. I think the challenge for the plaintiffs here is that they're not saying it definitely will. And I think if we're going to get to a private right beyond just the general administration of the election process, there has to at least be an allegation or some piece of evidence that says this voter is likely to be affected in some way. What we have instead is these layers of uncertainty, and we can talk about uncertainty for DJA in a minute, but it doesn't get to their private right.
But aren't the layers of uncertainty because most of these rules govern what the local boards of elections are supposed to do? And so an individual voter can't say anything with certainty about what is going to happen behind the curtain of the local election board, so long as there's a rule that gives that board the authority to do certain things. Why isn't it reasonable to suppose that those boards are likely to exercise that authority?
So I think it emphasizes the fact that the wrong parties are before the court here. If this involves the actions, the voters' concern about the actions their local board of elections might take, the remedy that local voter has is they can file a mandamus against their local board and say, under public right standing, I want to enforce the statute over the regulation. Alternatively, they could, maybe a board of elections, if it otherwise had the capacity to sue, could bring a declaratory.
Why is the state election board the wrong party? I mean, if they could achieve declaratory relief that the rules are invalid, why doesn't that give them all the relief from the injury they're alleging may occur?
So I think that the reason is the state election board, it's more if the state election board is the defendant of the state of Georgia through the state election board, the plaintiff needs to be a board of elections. It needs to be somebody with a more particularized injury, because if we're trying to enforce public rights.
We've never actually said that to challenge a rule as invalid, you need a particularized injury akin to injury in fact. We've certainly said that for challenges to statutes for separation of powers reasons. We've never said that for challenges to rules.
That's correct, Your Honor. And I think that the key point, though, is the reason why the more particularized injury is required is rooted in the separation of powers. It's the deference this court gives to the co-equal branch of the legislature. Here we have a co-equal branch of the executive that is acting through a regulation as opposed to a statute.
Except that for a statute that has been passed, the entire branch has acted. When we're talking about a rule that's been promulgated by one discrete agency, it is not the executive branch as a whole that is acting. And so I don't know that we have the same separation of powers considerations that apply there.
And that certainly is a consideration, I think. I think the key point, though, is if we look at this public right standing to actions of the executive, we are opening the door for the executive never really acts except through the governor fully as the branch. I think individual state agencies will frequently act as part of the executive. If you open the door to every voter having public right standing for every aspect of the election process, for example, you could have challenges to the types of voting machines we use, the types of other
That's only really a problem if they're not following the law, right? Because you can always just win on the merits.
You can, Your Honor, but I think, again, there's the gatekeeping aspect that we have to look at here in terms of how the people get into court.
On that point, then, counsel, how would it make logical sense to say that the remedy should be in mandamus when you could then, in theory, have 159 different mandamus orders governing a statewide election? I mean, how would that make any sense?
And so, Your Honor, I think that we have to recognize counties do run elections in Georgia, and I know that is difficult when we think about how many counties we have.
But an individual voter in Whitfield County in a statewide election has interest that in Bartow County it's going to be run the same, right?
Certainly, Your Honor, and we want to have as part of the goal of the SEB is to have uniformity in elections. We want.
Isn't that why, excuse me, why mandamus is also difficult? Because mandamus is only a remedy when there is a clear legal right, and the exact question that is trying to be answered here is this permissible? You know, does this exceed authority? There's only one. Mandamus can't answer that question.
So mandamus can't question the public duty. Certainly, it just has to say, here's the clear public duty. You need to follow it. I think the bigger point was if we had a situation where we're having multiple counties with different interpretations, it would then make sense for a Board of Elections to bring the declaratory action against the state election board at that point and get clarity. That's not what we have here.
Mr. Tyson, we focused on the voting rights in terms of standing. What about separation of powers and the violation of separation of powers alleged, the non-delegation claims that are alleged? Are there private or public rights implicated there that give a hook for standing for any of the parties? And if not, why not?
There might be, but I don't think those were ever alleged below in this case. The focus was always on the voting rights of the individuals. We talked about Mr. Hall as a board member.
In terms of standing, but the claims being brought are those substantive claims, and those are alleging violations of provisions that are sort of rights granted in the Constitution, whether you think of them as individual rights or something else. Why isn't that a separate basis for standing?
So I don't think it's a separate basis for standing because I just don't see it getting to the private right question of the individual. So we still are talking, I think, about a broad public right standing, even in that context, which isn't individualized or personalized to that person. So I don't think we reach standing on that front, even under that theory.
So I know you have limited time and you probably want to reserve something for rebuttal. Can we move on to the merits questions about some of the rules? Presuming, just for the sake of argument, that DOT versus City of Atlanta is not the controlling test, because I think if it is, you probably win on all the non-delegation arguments. Presuming that it's not, let's talk, for example, about the reasonable inquiry rule. The way I read 21 to 493B, that is a specific statute that says when the number of ballots cast exceed the number of registered voters, the superintendent shall go and investigate. And so you've got a statute that says here is one discrete context in which a superintendent has an obligation to go and investigate. Why doesn't the Latin canon that I can never remember or pronounce that basically says the articulation of one thing excludes that thing in other contexts, why doesn't that apply to keep the state elections board from essentially giving them broad investigatory power in other contexts?
And, Your Honor, I think that the main non-delegation piece from the state's perspective, and I know the RNC has a much more detailed discussion of non-delegation, gets to the fact that the SEB is unique. It is this unique agency in a lot of ways. And I understand your question is getting at the merits issue, and for the state's perspective, from the state side, We are standing on the merits issues raised in our principal brief, but are not making further argument on the merits of the individual rules in this court at this time.
What, in your view, a lot of your argument hinges on the idea that the state election board is unique. Can you just explain briefly why you think that is dispositive compared to other entities?
Certainly. Just the court in Atlantic Games talked about it wasn't the right vehicle to get at these non-delegation questions that I know the court is interested in reaching. The state election board sits as a very unique agency. It is in the executive branch. It is majority appointed by the legislature. It doesn't have broad, unfettered rules.
So if it's really unique because members are appointed by the legislature, is perhaps that uniqueness itself a violation of the separation of powers?
It does posit the state election board as different than most executive branch agencies, certainly. And I think the changes in this makeup of the election board really happened in 2021 when the secretary was removed from the state election board. But in this case, no one is challenging the configuration or the operation of the state election board. So I don't think that question's before the court, even if it is an issue that is unusual.
But the nature of your argument, I think, and please correct me if this is not right, is this is even more executive than usual. Or are you saying it's even more legislative than usual?
We're just saying it's unlike other executive branch agencies.
Right, but there has to be an implication of that to reap a benefit from it legally, right? Just being different doesn't absolve any kind of separation of powers concern.
Certainly, and the key is just that any ruling this court made about non-delegation in the context of this very unique agency wouldn't necessarily address the non-delegation
You're just
question.
hoping the unique nature means we don't get to it.
So
Correct.
I think the importance, I think the questions are pointing out is that the nature of the uniqueness has to matter. That is to say that the Board of Department of Natural Resources is unique in that it is the only board that deals with natural resources. But how would that uniqueness, explain for us why that unique characteristics or the unique characteristics you identify mean that it has a different set of rules?
Just because most executive boards are appointed by the governor or are overseen by boards that are involved in gubernatorial appointments in some way. This agency is different in that vein.
And what is the import of that difference? I mean, I get the difference you're describing. I'm trying to understand why that would change the rules that it has to operate under. The fact that it has a different constituency or appointing mechanism, what is it legally that makes that different?
So when the legislature is doing the delegating, basically, it's delegating to a body that it self-controls, which is different than delegating to a body that the executive
Which does raise
controls.
serious questions about whether separation of powers permits that. Because if it's different for reasons that matter for non-delegation, it's different because it may be sort of kind of legislative. I do recognize the sensitive position the state is in, given that the Attorney General had advised that the State Election Board could not in fact do what it did.
Would that same structure, would that same analysis adhere to the state DOT board?
The state DOT board obviously is elected by the legislature, you're correct. So I had not looked at some of those other elements. We were looking specifically at would it be a non-delegation problem from the legislature to a board that it
Well, I'm just saying, you're representing it as unique, and I mean, the state DOT board is elected by the legislature, so it's not unique
That's
in
correct.
that respect.
Although I think it is unique in the sense that the Constitution provides that the DOT board is elected by the legislature, whereas the state election board is statutory in nature.
That's correct, Your Honor. And I see I have 5 minutes remaining. I'd like to reserve that for rebuttal if I may. We would urge a reversal based on standing. Thank you, Your Honor.
Thank you, counsel. Good morning. You may proceed.
Thank you, Mr. Chief Justice, and may it please the court. Gilbert Dickey on behalf of appellants, the Republican National Committee and Georgia Republican Party. Given that it's the most sweeping issue on the merits in this case, I'd like to start with the non-delegation issues that the court was discussing. The non-delegation doctrine is not a prohibition on the executive exercising any discretion. It is a prohibition on the legislative exercising legislative power. Each branch exercises broad discretion within its own sphere. That's why, for example, this court does not need specific guidance from the legislature before it can enact a rule of civil procedure for the lower court.
Mr. Dickey, can we sort of cut to the presiding justice's concurral in Atlantic Games, which set out this kind of three-step understanding of how to analyze non-delegation claims? Can you let us know, do you agree with that articulation of the standard? If not, sort of why not, and then sort of cast your arguments within that, to the extent you agree with it.
I agree that each of those three steps are steps that are necessary in a non-delegation case. I think what we often term the non-delegation doctrine is sort of the substantive standard that you apply at step 3 to decide if a agency is exercising legislative authority.
And then that step is, you would agree about whether what's being, quote, delegated is some kind of legislative power, or if it's instead sort of naming the executive agency and saying sort of what they can do to execute the law. Is that the line we're trying to draw?
Yes, I think the line we're trying to draw, and I hope this came through in our briefing, is we believe the line there is primarily qualitative, not quantitative. So the ultimate question is whether the kind of power being exercised is the kind that could historically be exercised by the executive.
So in your briefing, the line you posit between legislative and executive power is whether a rule or a statute generally governs private behavior. And the case law I see for that is entirely federal case law. Where in Georgia law do you actually find that being the line between executive and legislative power? Because there are entire volumes of the Georgia Code that the General Assembly has enacted that are just governing the actions of government entities.
So I would agree that this line is not as clearly presented in the Georgia case law, but I do think if you look back through the Georgia precedents, I would agree that the more modern precedents have increasingly focused on the quantity of discretion. But I think if you go back historically, there has been some focus on the quality of discretion in the Georgia case law. I would cite as maybe a first example of this, the court's decision in Southern Railway v. Melton. There, the court noted that there are some matters over which both the multiple branches can exercise some discretion. It cited as an example of a matter over which the executive could legitimately exercise discretion the granting or revocation of a license, which is, of course, traditionally a matter that is treated as a public right. And it contrasted that with the ability to create a penal law, which it said would always require an exercise of the General Assembly's authority. I think maybe the best example of this might actually be the decision that you cited in your recent Atlantic Games concurrence, Justice Peterson, in Bedingfield v. Parker. There, the court, in a very terse 3-sentence assessment, says, there's a non-delegation claim raised here. They're arguing that there's not sufficient guidance for the county on the consolidation of the school districts here. But historically, county school boards have long exercised general discretion over the location of schools. And with that analysis, the court was able to reject the non-delegation claim. There was really no assessment of whether there was adequate guidance.
Although that context doesn't map on perfectly well here, because within the division of authority in Georgia, you have both the division between branches, which is typically what non-delegation is about, but you also have the division between state government and local government. And the Constitution reserves for local school boards certain authorities that no part of state government can exercise. And so I'm not sure that case is necessarily on point here.
I'm not sure whether that distinction would matter for the issue that has been raised by the plaintiffs here, which is whether the authority is legislative versus executive, as opposed to some vertical authority distinction between the state and the county governments. And there, the issue being raised, at least as it was presented in the court's opinion, was whether there was adequate guidance to make the act of the county not something required of the General Assembly.
So do I have to buy your argument on what the legislative power is limited to in order to rule for you on these rules? If my view of the nature of legislative power is more expansive, do you lose?
I don't think we lose if your view of the legislative power is more expansive. I think it would, of course, depend on your particular view of what the legislative power is. I don't think there's been I think what we most want to emphasize to this court here is that, in our view, the argument advanced against these rules is that this court should draw a quantitative line and that there's just too much discretion given to the state election board. We think that's a standard that is both incorrect There are several decisions before the modern decisions of this court that do seem to draw a more qualitative line. I would cite all the decisions cited in our brief about the inability of an agency, even at the state level, to define the contents of a crime. And if you look to Justice Thomas's sort of history of federal non-delegation doctrine in his Amtrak decision, I think it'll illustrate to you why there must be a qualitative line here.
So I don't disagree with you that it's not just about the amount of discretion, it's about what that discretion allows. In other words, is it a discretion that allows something that looks a lot more like making law, or is it something else? Is it sort of implementing? And I think a lot of people have struggled with like what that line is and what that looks like, but I guess I push back on the idea that it's just a quantitative line, but it does seem here that some of these rules cut against the idea that it's not just discretion, it's discretion that looks a lot like sort of setting up their own sort of mini set of laws that govern, that aren't sort of connected to anything in the code.
Well, for that, I do think you need a definition of what the core of the legislative power here is. And
that would be helpful.
And we would suggest that this court adopt the standard that goes back to Blackstone, which is the law is to the ability to establish a generally applicable rule of private conduct. None of the rules do that here.
It can't be just that. Like the presiding justice said, the legislature often enacts laws that don't directly govern private conduct. Eventually it gets to it, but
Title 45 almost in its entirety would exceed the legislative power if the legislative power was limited to only governing private conduct.
So this is why I think the distinction in Melton, and going back to Chief Justice Marshall's opinion in the Wayman decision, and what I was about to discuss in Justice Thomas's opinion is important. There are some matters over which multiple branches can exercise discretion. What is fundamental in the non-delegation doctrine.
Well, but I mean, I'm not sure that the presiding justice example is an example of multiple branches being able to exercise necessarily. I think he's just saying that there is a more expansive power of regulation from the legislature than merely private individuals or private conduct.
Yes, I think, I guess in the terminology I'm using, when the legislature acts, for example, to empower this court to issue rules of procedure, it could also enact rules of procedure for the operation of the courts, because that is something.
So I'm not sure that's actually right under the Georgia Constitution. Let's take a different example. Title 45 prescribes how resignations from public office are effective. Could the executive also provide how resignations from public office are effective, or is the fact that the legislature has done that mean it's exclusively within the legislative power?
I think the mere act of legislation would not make the executive providing further guidance inherently a legislative act. Whatever the executive does, if it is within the purview of things that are subject to the discretion of both branches, would have to be consistent with what the legislature has done. And I would just point out briefly, in terms of drawing this qualitative line, this line is historical and goes back to a traditional understanding of executive powers. The two features we highlight in our briefing are the same ones that, as Justice Thomas explains in his Amtrak decision, Chief Justice Marshall relied on in Wayman, which was it's a qualitative, not a quantitative line, and the courts were giving directives to lower judicial officers. With that, I see my time is up. We would ask that the court reverse the decision below.
Thank you. Mr. Nowitz, you may proceed when you're ready.
Mr. Chief Justice, may it please the court. This court has been crystal clear in the last 5 years as to what its standing doctrine is as it relates to the standing issues that are before the court. It is found obviously that when an individual expresses a right that violates some personal issue like voting rights, private property interests, or liberty, you've got standing. It is clearly said that individuals have a right to bring actions under the doctrine of community standing if they are part of the community that is being affected by the challenge.
So We have not yet extended community stakeholder standing to suits against the state, in part because the rationale for community stakeholder standing originated from suits against cities on the theory that cities are municipal corporations, and essentially community stakeholders were shareholders in the corporation, and so they could essentially bring shareholder derivative actions against the cities. Now that's broadened over time against other local governments, but what is your best argument for why that principle should apply to suits against the state?
Sure. So first of all, the principle that where that is derived from is the common law doctrine of allowing suits against the king. Suits against the king's subordinates. And as this court has said expressly in SCV, that subordinates are typically seen and typically understood as localities. But the court goes on to say that all bodies deriving power from statute, decree, or charter, citing Louis Jaffe's 1961 Harvard Law Review article, says that when you derive power from a statute, that is a subordinate of the king, and here the state election board derives its power solely from statute. It is not like the governor who is created by Constitution. It's not like the Attorney General that's created by Constitution. This is clearly a subordinate of the government. Moreover, in the
whose subordinate is it, though? I mean, the state argues about sort of the uniqueness of the state election board. Whose subordinate is the state election board?
Well, I'd say mine, but and the people's. But that's a problem. I mean, you pointed out the constitutional problem with the construction of the state election board. We had a lot of issues here, so we didn't raise that one. But who is it a subordinate to? I mean, Georgia's constitution was set up in 1777. It basically vested a huge amount of power in the legislature, a very little amount of power in the executive. And that has changed over time. But, the way that our Constitution is set up, it imbues these different executive branches with constitutional authority, and then we have a number of agencies that are set up legislatively, and at least according to my understanding of how that applies, it's not a direct corollary to the King's England. As a matter of fact, we shunned that system and had a whole new system that we adopted in our Constitution. But whose subordinate is there? I mean, the best analogy is that it's a king. The best analogy is that it's subordinate to the executive. It is an executive body, as admitted by the state election board in their briefing. And so to the extent that it is a subordinate, it is a subordinate to the executive. And here is the people, and we saw that in the Barrow versus the Raffensperger versus Barrow case. The court expressly said that when the rights of voters are implicated, whether or not they have a specific injury, they can seek a remedy not only against the subordinates, here I think the SEB is clearly a subordinate, but can also seek that remedy against the Secretary of State itself.
So can we talk about how that would apply in the context of your challenge to a particular rule? Mm-hmm. Eternal Vigilance asserts a claim against, for example, the poll watcher rule. Mm-hmm. And it may be that you have organizational standing to challenge that because under the statute you may be a political organization with rights to have your own poll watchers. My read of that rule is that it actually expands the ability to have poll watchers. What is the right that would be violated by that?
Sure. So this court has said that rights that are affected by community standing include the right to make sure that the law is enforced and that votes can be injured when elections are not administered according to the law, and that's SCV and Barrow, and they cite federal cases.
Well, but that's the sort of public rights side of the standing analysis. I think what the presiding justice is articulating is potentially a private right of the organizations who have their own right under the statute. So stick with that for a minute. Okay. What right is being violated under the statute if the rule is expanding?
Under the poll watching rule. Yes. So under the poll watching rule, that particular rule says that poll watchers must be allowed in certain places. The General Assembly recognizes that there is a balance. There is a balance between intimidation of poll workers, intimidation of election workers.
Right, but if, as the presiding justice suggested, it would allow your organization even more access, how is there harm derived from that rule that your group suffers?
Sure. Well, I guess what I'm arguing is that it's in harm to the administration of justice. That basically when these poll workers are trying to count votes, I mean, obviously we're going to allow some people, and the General Assembly says you have to allow these people in these certain places.
So your theory is like, even if we get to be there, there are just too many people there.
Well, I mean, I think that the General Assembly has weighed the balance. It's a policy decision getting back to what is legislation.
I mean, it sounds like, that answer sounds like you're almost conceding or acknowledging that it doesn't affect their right to be a poll watcher, but you are relying on the sort of broader, potentially public right.
For that particular statute, I think it's more of a community standing argument. For the other ones, I think it directly affects the right to vote.
So if we don't adopt the community standing premise, then how does that lend favor to your argument?
On the poll watcher rule?
Yes.
Again, I think that the poll watcher rule, I mean, there's 6 or 7 rules that we're challenging. On the poll watcher rule, I think that is primarily a community standing argument. The rest of them, I think, more directly affect the individuals. But here...
Same with the daily reporting rule?
Well, I think that the daily reporting rule can also be, I mean, that's a little bit more, I think you're right, that's more in the nature of community standing. All the rest of them directly affect voter rights and organizational rights. But for those two particular, I would concede that those are more community standing.
So the state and the RNC has identified 3 separate statutory grants of authority for the SEB to promulgate rules.
Right.
And at least one of those is exceptionally broad, if you read it just according to its plain text. If DOT versus City of Atlanta is the standard that we apply, do you lose on the merits?
No. I mean, I think Premier Health answers that question. When you look at the rules, and in that case, a private individual saying that these rules are being, a private company is saying that these rules are being enforced in contravention of the law because they expand the scope of what the legislature has said. And here, when you take a look, almost all statutes that create boards have broad powers to delegate certain rulemaking authority, but that rulemaking authority must be read through the lens of the Constitution, and the court will typically try to review that statute and ensure that it is constitutional as it has done before. And in looking at it through that lens, it will say, okay, you have the authority, state, to do and create rules that the Constitution allows you to create. And here, the Constitution does not allow them to create that.
Well, but DOT's constitutional holding is that the guidance a statutory conferral of rulemaking authority has to provide can be unbelievably general and vague.
Well, I don't think this court's decisions, and certainly not federal decisions that applied the same standard, have said that very broad rulemaking, you cannot impute to the General Assembly an intent to do something which violates the Constitution. And so here, you can either say, I'm going to construe the statute in a narrow way that conforms with the Constitution, and the SEB, and this is our primary challenge, is that the SEB is acting in a violation of the separation of powers doctrine by engaging in legislative activity.
But it's only legislative if the guidelines that the statute provides are not sufficient. And what DOT says is, the holding in DOT is a guideline that the rule serve the public interest was specific enough.
Well, I think that
if that's specific enough, why isn't the statute that says, just go pass rules that will make elections fair?
Well, I don't think that's, I mean, the delegation here says that the rules must be in compliance with the election code, and I think as we pointed out in our briefing, they are directly contrary to the election code. What Premier Health also says is that when a state legislative body tries to add to, detract from, or do anything other than execute the law, then that raises serious constitutional questions. And so I mean, my reading of Premier Health is that it is not allowed, but going to.
We don't really have a substantive non-delegation holding in Premier Health. We just noted there might be issues, and so we applied constitutional avoidance.
Exactly. But implying the constitutional avoidance, the court said that when the regulatory body is expanding the scope of the statute, that's legislation, and we're not going to read it that way. That's how I read the case. But getting to your primary point about DOT, I think that the separation of powers issue is obviously the driver of this case. The separation of powers issue, there are a number of constitutional provisions at play. Number one are the vesting clauses, where all of the legislative authority is vested in the legislature. And number two is the separation of powers clause. And the separation of powers clause obviously says that the legislative, judicial, and executive powers shall forever remain separate and distinct, and no person discharging the power or duties of one shall at the same time exercise the functions of the other. That is very clear. And as with all things legislative and constitutional, we start with the language of the provisions. And here the provisions.
So what is, the RNC has made an argument based on a lot of federal precedent in the common law as to what the nature of the legislative power is. How would you define the legislative power? Do you agree with their definition, or do you have a different one?
I do not. I think that the legislative power is the power to make policy, is the power to create direction to people as to how they're going to conduct their business.
Well, but if we start from the proposition that if something is legislative power, then the executive can't do it, which shall remain separate and inviolate forever, seems like is what that's saying.
Yes.
It can't be as broad as just making policy, because the executive branch makes a lot of policy. Frankly, we make some policy in the judicial sphere.
Through adjudication, I think you clarify the law.
I'm not talking about deciding cases. I'm talking about exercising judicial power to govern the judicial branch through the Judicial Council and other.
Yeah, and I think that part's right. I mean, if you're going to pass rules that govern your own conduct, then, I think that would be within the scope, because you're creating rules that govern your own.
Well, but that's transfer that to the executive branch, and that sounds a lot like the RNC's argument that what they're doing is enacting rules that govern the executive branches, the executive agency's own conduct, and therefore it's fine. So
I don't think it's governing the entire executive branch. I mean, I think it's
no, but the state election board.
Well, it's not.
But that it's not
governing
private conduct.
Well, it's governing the conduct of how the localities are administering and counting votes, doing certain things that affect private conduct. And when you look back in your history to get back at what the legislative is, I mean, we look at it, separation of powers was a pretty big deal, right, in 1777. And it was established, by Locke, Montesquieu, all these people. Madison talked about it in Federalist 47, Federalist 51, Federalist 10, John Adams, Thomas Jefferson.
I don't think you have to convince us that it's a big deal.
It's a big deal. And the important point is when we're trying to interpret what we meant in 1777 and carried forward, there are very clear demarcations between legislative, judicial, and executive power. And all of them, at the time that we formed this republic and the time that we formed this state, said that it could lead to tyranny. It was that big a deal that we want to ensure that these things are separate and apart. And the decisional law of this case, looking back at what was happening at the time, the decisional law of this case in Beal versus Beal, Franklin Bridge, Premier Health, Medical Association versus
So coming back to the nature of the legislative power, one articulation that you will find in our case law is the legislative power is the power to say what the law shall be. That's usually articulated distinct from the judicial power, which is the power to say what the law is. But really what the RNC's argument is, yeah, but you can only make law on these sorts of things. And if it's not this sort of thing, then the executive branch can do it. What is the limitation in the Georgia Constitution on the nature of the kind of laws that the General Assembly has authority to pass?
I mean, I think that the General Assembly has the authority to pass. I think that the constriction, it's a very broad legislative grant for sure. And then to this articulation, it cannot delegate its legislative function I think at all. But certainly.
Can we
Yeah.
move for a minute to the sort of Atlantic Games
Yes.
framework? It seems like we've been focusing largely, if not entirely, on sort of step 3, which is
Right.
differentiating legislative power from sort of executive.
Mm-hmm.
Do your arguments sort of track all into step 3, or do you think that some of these rules are potentially invalid at step 1?
I think they're all invalid at step 1. I mean, I think that the separation of powers issue obviously underlies steps 1 and 3. Step 2, I think everybody agrees is met. With regard to step 1, I think that if you look at the delegations here, the delegations are pretty specific. They say that you have to enact rules that are consistent with the laws, the election code, and you have to enact rules that are going to enforce conformity with the processes of going through the voting. And if you just take the first part, that it has to be consistent with the election code, what we have done is we have shown in every single area why those rules have adopted something that the General Assembly has expressly declined to do.
How about something like the Dropbox surveillance rule?
So the Dropbox surveillance rule, I think, is one of the best examples. So in the Dropbox surveillance rule, the General Assembly said, we are going to make sure that these Dropboxes are monitored by what? By people. And they had a reason that they wanted.
Does the General Assembly's statute actually say that it has to be monitored by people?
Yes. It says it has to be monitored by these certain groups of people, the sheriff, and or other people appointed by.
Does it say they can't use video monitoring to do that?
It does not say they can't use video monitoring, but what we know from the time of the enactment is that the prior SEB rule, which was created in the 2020 election, prior to the 2020 election because of COVID, it explicitly had in there a provision for video monitoring. That rule became something that the legislature looked at and debated, and for a number of reasons, it excluded what had been in the prior SEB rule.
But is
And so
there
I think that's
any
considered decision.
statute that, by the terms of the statute, excludes video monitoring now?
I think yes. I mean, I think what it says is that these people will do it.
Does it exclude?
No, it does not exclude it, but again, getting back to Premier Health.
If the sheriff has a video monitor at the sheriff's office and they've got the camera on the Dropbox and an agent of the sheriff is watching that monitor, why isn't that the sheriff monitoring the Dropbox?
I think that as I read the rule, it requires a physical presence, but I mean, and one of the reasons why that is I think that the rule was trying to prevent people with 80 ballots from walking up and shoving them in a box, because those have to be counted. If you've got video on that, you're not going to be able to prevent that. Those rules have to be counted. The General Assembly didn't want that to happen. And here you have somebody in place to say, okay, you can put your one.
Well, but the word is surveillance. It says constant surveillance, not constant bodyguards. I mean, that seems like a pretty odd interpretation.
Well, what I know as a matter of fact is that and this is in our briefing, is that specific video issue was presented to the General Assembly and they rejected it for whatever reason. And just because.
But I mean, legislative inaction is a sort of notoriously tricky argument to make. You say for whatever reason, it could have been because they thought the rule already allowed it.
Well, they could have, but this.
And how are we to know which reason is the reason?
Sure, I think that this court's cases have said when you look at the history and there is language in one place, the General Assembly takes it out, and again, admittedly,
That's for enacted language.
What's
That's
that?
for codified language.
That is codified. Like I said,
This is
admittedly,
not.
that's codified language. But here we have a clear evidence of the history, and if we're trying to figure out what the General Assembly's intent was as to that particular bill, that's all we have to go on, and we know that they cut it out. That has to have meaning. And just because, and the state election board said, well, I don't like that, we're going to put it back in. They obviously think it means something. They obviously think that it needs to happen, and they are implementing something that the General Assembly said no to. Thank you.
Thank you, Mr. Nowitz. Lee? Good morning, Council.
Good morning, Your Honor. Mr. Chief Justice, and may it please the Court, Teresa Lee for Appellees, Georgia State Conference of the NAACP, and Georgia Coalition for the People's Agenda. The Georgia NAACP and Coalition for the People's Agenda challenged the hand counting rule. And quite simply, that rule directly conflicts with the election code. The operation of the rule undermines the statutory scheme to secure the election, for which the required statutory immediacy is for the purpose of ensuring chain of custody of cast ballots. And it undermines the statutory risk limiting audit by repeated handling of the ballots that would be used for those purposes. The General Assembly has set out a comprehensive system for the conduct of elections, and the State Election Board is only authorized to promulgate rules, quote, consistent with the law. And that's made clear not only in the SEB's originating statute, but also in this court's decisions.
Counselor, is your main stance that ballot security is more at risk by the hand count rule?
That is sort of the policy reason underlying why the legislature has set out the specific procedures it has with respect to the conduct of poll workers at the close of the polls. And the hand count rule conflicts with those statutory requirements. And I want to highlight.
So you started with this point, and I think it's a critical textual point about the language consistent with law. What is the standard for a rule being consistent with law? Obviously, it can't contravene, it can't directly contradict what the law says. But, let's say the law isn't specific on something. What is the room for a rule to bring specificity to the election law regime that the statutes just don't afford?
Certainly. Sort of as putting a pin in an initial point is that we contend that the hand count rule actually does contravene law.
Right.
But as to the broader question, Your Honor, the standard is that it effectuates, carries into effect a law already passed. So, for example, in this context, the statutes of the General Assembly include, for example, that ballot boxes be sealed, right? And so certainly an executive agency so charged with ensuring the execution of that law could specify what type of containers would sort of satisfy those standards. And so, of course, we recognize, as the state and the RNC cited, the fact that there is some room for additional specificity, but we think that specificity has to be carrying out something.
Is that the only room that consistent with law leaves? Is it only being more specific about things that the statute already touches on? Or does it leave room to do things that the statute doesn't touch on, but is just silent on?
I think if the statute's entirely silent and it's creating some entirely new requirement, I think we're straying into declaring what the law shall be. There needs to be some touchstone to what law is being executed by that executive branch agency.
I think you're highlighting an important point that's unique to your client, because in some ways the argument you're making is almost like a preemption argument. Like if the law says this, then the regulation can't say the opposite of this.
Yes, Your Honor.
But the much harder question is just what the presiding justice touched on, which is it is easier to ascertain that kind of analysis if the law is very specific or clearly affords some kind of discretion. But when it is totally silent as to something, what do you think the touchstone is? You started on this, but what is that touchstone of how to figure out if that is an appropriate exercise of authority?
I think the touchstone would be that whatever the ruling question actually executes a statute, right? If we're talking about executive branch actors,
but if the statute doesn't say it,
then I don't think it's something an executive agency would be allowed to do.
And so that's where I think it gets tricky, because it seems like that's too bright of a line in the opposite direction.
I don't think so, Your Honor, because I'm not saying that the statute itself needs to list every single possibility, and therefore what would be the point of any rulemaking.
Is it your position then that the executive branch has to have a law to execute that law? And then the manner in which it executes, it has some sort of discretion so long as it doesn't break that law, but it cannot execute a law that does not exist? Is that?
Yes, Your Honor.
Well, what about the statute that says pass rules that make elections fair?
I think we're sort of running into the question of step 3 under the DOT case, then, Your Honor. I don't think it only says fair, right? All of those portions of 21-31 give a list. It's not pass rules that make it fair, pass rules that make it orderly. It's
fair and X and Y and Z, but surely not every rule has to serve every single one of those purposes to be valid.
I think that the meaning of those provisions inform one another. The meaning of each of the items within the list inform one another, and I think there is another Latin phrase that I too am not recalling or would pronounce correctly, even if I did, that speaks to that idea, just as a matter of statutory construction. And so highlighting two of the ways the hand count rule directly conflicts with the code here. It conflicts with the statutes that govern procedures at the close of the polls. Most importantly, for our purposes, 21-485, which governs those procedures in precincts that make use of optical scan ballots. Further, the rule fails to comply with Code Section 5013-4, which requires citation of authority that actually authorizes the rule.
Do we have any case law that says failure to cite the right statute invalidates a rule?
Well, I would suggest that the statutory language of 5013-4D, which requires exact compliance, provides the basis for that, which declares without exact compliance.
So it's always okay to come in here and say the text of a statute gets you there without case law, but I was just curious if we had anything that had applied that.
I believe there are a couple of cases cited applying that exact provision language in some of the amicus briefs, but I don't have that in front of me, Your Honor. So turning to 21-485, that statute requires that, quote, as soon as the polls are closed and the last elector has voted, the poll officers are, quote, required to seal the ballot box and deliver the ballot box to the tabulation center. The straight text of the statute simply doesn't allow for this unwieldy atextual process that under the terms of the rule need not even begin until the next day. After the procedures at the close of the polls, further portions of statute then direct that poll workers must immediately deliver all required documentation and election materials to the superintendent, right? And so these provisions make clear that the hand counting rule, you cannot comply with both the hand counting rule and statute. And for that reason, it is necessarily sort of outside the authority of the SEB for it to enact and in conflict with the SEB's own originating statute. And I would, in my closing moments, Your Honor, I would also just point the court, the provisions discussed as not providing the authority for the rule are the provisions discussed in the lower court's opinion, and which are detailed in our briefing as well. And so we believe the court should find the hand count rule invalid, and it can do so on the narrow ground that it conflicts with the election code as passed by the legislature. Thank you, Your Honor.
Thank you, Ms. Lee. I see no further questions. Mr. Tyson, you have some time remaining.
Thank you, Your Honors. I'll begin with the organizational standing questions that were raised about EVA. I think it emphasizes the public right nature of the claims that are being brought in this case, but I think it also illustrates the record before the court is that EVA's injury that it says it has, it focuses on the federal standard of it has an injury of diversion of resources. And this court has discussed the whole damage without injury situation. If there's not a private right of EVA that is being implicated, whether it's diverted resources is really irrelevant to whether it has standing to bring the actions before this court. And so we would emphasize that from an organizational standpoint, the record doesn't support that there's this broader private right. The plaintiffs don't even try to identify a private right. They point to the federal standard, say we have a diversion of resources, that's enough. An individual doesn't get standing by spending money in some way. I buy an advertisement, therefore I have a private right. In the same way, an organization can't do that either under this court's case law. I also wanted to just discuss the question of how we deal with this community stakeholder standing in the state. I think the court can say the limitation is mandamus. I think that's one path to say that if you're going to go down that road, mandamus in many ways is self-limiting. It has these particular procedures around it. It focuses on the public duty and addresses the question that way. And I think the other question that the court needs to address that we haven't really discussed today is the level of uncertainty under the Declaratory Judgment Act. Even if someone had an ability to bring a public right standing case against the state or against an executive agency, they would have to have enough uncertainty to invoke the Declaratory Judgment Act.
Why wouldn't Plaintiff Hall have that uncertainty as a member of the Board of Elections? I mean, how is he supposed to provide guidance as a board member if he doesn't know which rule to apply?
So the record before the court, Your Honor, shows that, first of all, Mr. Hall says he's very sure these rules are illegal, so he doesn't need guidance on that. He does say he needs guidance about his direction to the employees
But if a person thinks something is illegal, doesn't that still create uncertainty about, even if that's his personal belief, like what's next?
Most litigants in court are convinced that their side is correct.
Certainly, Your Honor. I think the bigger question for Plaintiff Hall is that he's not the board, and the board isn't here. And so a multi-member board can only act.
But he has taken an oath to follow the law, and so he has to decide how to vote as a board member. And so if, in fact, these rules that he thinks are invalid are valid, then his oath requires him to apply them, right?
I think that would be correct, Your Honor, but I think the key part of the oath issues that have been raised, they were not raised below. And so the reference to any oath happened in passing in the hearing. Mr. Hall does not say in his declaration that he's worried about violating his oath. His oath is to the laws, not to the Constitution. But I think the bigger challenge is if taking an oath is enough to confer private right standing. We swore in some new lawyers to this court recently.
Well, not necessarily private right standing, but at least a hook under the Declaratory Judgment Act for the uncertainty, because even though he's not the board, he does have to take action in his own right in voting along with the other members, right?
I think that's correct. So I think that if we get past the standing question, the oath could provide uncertainty, but I think you have to get past standing first.
Can we turn back to, you mentioned the community stakeholder public rights standing against the state. Is another way to think about that potential limitation that you still need a sort of private right of action when it comes to the state? So we have this long line of cases and under community stakeholder standing that kind of gives you that right of action against local governments, but we don't have the same thing for the state. And so you need to, at least in a public rights case, identify some private way of bringing the suit beyond just identifying the right shared in common.
I think that would be a way to look at the limitation. And so I think you focus then on the particularized element of the injury at that point. Essentially, you're getting to that bigger question, because then you do have a private right. You're not proceeding only under public.
Although, I mean, when we talk about private right of action, doesn't the Declaratory Judgment Act provide a private right of action so long as you satisfy the standing required for claims under that statute?
It does, but we still have to get, I guess we're kind of trying to circle around what the right.
We use the phrase private right a couple different ways in this context.
Certainly, that's right. Private right as part of your standing versus a private right of action. So I think at the end of the day, though, the most important piece is there's something more that is required when you're moving against the state, and that is what is lacking in this case and why this court should reverse with direction to dismiss for lack of standing. Thank you, Your Honors.
Thank you, counsel, and counsel for both sides. For the final argument, we will try to have you a decision as soon as possible. With that, we will be in recess for about 10 minutes. We'll come back and hear the final case.
All rise.